I call the conference committee on Senate File 3492 to order. We have a quorum present. Welcome. Our plan is to walk through the DE, take public testimony, and then adopt the DE. So we'll start with nonpartisan staff to walk through the DE.
Chair and members, this is Mary Davis from the House Research Department. I'm going to start on the document.
I don't know if your mic is on.
Right, there you go. Mary Davis from House Research. Chair and members, I'm going to start with the document, the A24-0330. On page 1, section 1, it allows evictions to be expunged when the eviction occurred in violation of a law that allows crime victims to terminate their lease due to criminal or sexual assault or domestic violence. Sections 2 and 3 add new definitions to the Chapter 504B for tenant association and tenant organizer. Section 4 expands the definition of the term violation for Chapter 504B to include a violation of any federal, state, or local law protecting tenants from discrimination or providing requirements for subsidized housing. Section 5 creates a new definition for the terms abandonment of tenancy and abandonment of personal property for Chapter 504B. Section 6 adds a disclosure requirement and remedies related to pet fees and accommodations for service animals. Section 7 requires a landlord to accept a taxpayer identification number in place of a social security number on a rental application and prohibits the landlord from delaying the application because the tenant used an ITIN. Section 8 clarifies existing law on how landlords must disclose mandatory fees that tenants have to pay in addition to rent. Section 9 clarifies how long the landlord must wait to request a renewal of a lease. Section 10 provides definition, requirements and remedies for a tenant when the landlord is unable to allow the tenant to occupy a rental unit because of ongoing construction related to the residential unit. Section 11 provides a tenant's lease obligation ceases when another tenant begins a new tenancy for the same unit that they left, and it requires the landlord to fill a vacancy if a tenant leaves before their lease is up. On page 6, starting around line 23, we're looking at section 12. This updates, clarifies, and expands the covenants of habitability required by landlords for residential rental units. Section 13 prohibits a landlord from denying a rental application based on a pending eviction case filed against the prospective tenant. Section 14 requires landlords to charge a late fee to renters for using public housing vouchers consistent with the tenant's portion of the rent, not the portion paid by the voucher program. And Section 15 clarifies when a landlord can accept rent related to condemnation and provides that violating that section of law is a violation of the covenant between the tenant and the landlord. Senate Council is going to pick up there.
Madam Chair and members, Priyanka Primo from Senate Council. I'm beginning on page 9 of the A24-0330 document. Sections 16 and 17 clarify a tenant's right to call for emergency assistance in response to a health crisis. Sections 18, 19, 20, 21, and 27 all clarify the rights of a tenant who is a victim of violence. Section 22 provides for a tenant's right to organize. Sections 23 and 24 require screening companies to update the status of court records before they issue a tenant screening report and provide for additional remedies for a violation of the tenant screening law. Section 25 provides that only one of the tenants has to meet the qualifications of an infirm tenant in order to allow all tenants on the lease to move out pursuant to the current law. Section 26 clarifies the right to counsel in public housing evictions. Sections 28 and 29 provide updates to the service procedure for eviction actions. Sections 30 and 32 provide technical clarifications related to those updates for eviction actions. And Section 31 provides that the Attorney General may enforce violations of Chapter 504B.
Thank you. And next we will go to public testimony. We have 2 people signed up, so we will start with Cecil Smith. Please keep your comments to 2 minutes, and thank you.
Madam Chair, members of the committee, I just want to walk through some of the elements. We have two primary concerns. One is the section related to disclosure of fees, and then the enactment dates. To walk through the enactment dates quickly, on page 1, the effective date is following final enactment. In the Senate Judiciary Committee, there was discussion about this. The recommendation from the chair was 30 days so that our members would not potentially be immediately in violation of the law, not knowing that the law had changed. This section of law on domestic violence and the following sections are extremely important, but we do need a little bit of time to let people know that the law has changed, because there could be a circumstance in the next couple of weeks, presuming that this passes, that our members of the Minnesota Multi-Housing Association could find themselves in violation of the law, and that would be serious, with serious consequences, especially related to the section about disclosure of information, which has a $2,000 fine. Moving to page 3, we would recommend on 3/15 a January 1st enactment. We need to train our members. We have many leasing agents. We have leases that will have to be amended to provide for this section of law, and we need time to make those adjustments and train. On the disclosure of fees at the bottom of page 3, we believe this is unworkable related to the optional fee portion of this language. To include that in the monthly rent when people change pets, people have an EV that they need a charging station for, and then they don't need a charging station because they have it at work. How this gets included in rent, in a base monthly rent charge, is confusing, because these optional fees, whether the resident wants to rent the club room or not, is at the resident discretion. And how we are meant to change the lease every time they use optional fees is concerning, and we believe almost impossible to implement. Would also note that this is the first time we've seen this language. There wasn't a bill, it hasn't been heard in committee. To the bottom of page 4, again, we're concerned about the final enactment being the effective date on early lease renewal. We would suggest that August 1st would be more appropriate. New construction and delays on tenant remedies, that's fine. If we go to page 7 on denial based on pending cases, this affects thousands of leasing agents. This is line 719. We would suggest January 1st for enactment. We need to train leasing agents who are doing tenant screening across the entire industry. We need to train them because this has lots of nuance related to eviction cases, and they need to understand the difference between a pending case, a dismissed case, cases, non-public records. We would recommend that date.
Thank you, Cecil. If you want to wrap it up.
Yeah, I'm trying to get through our recommendations on enactments. On the 8/13, we would recommend an effective date of August 1st for the aforementioned reasons. Again, all the sections on domestic violence, we would recommend 30 days following final enactment on 10/24 and 11/30 and 13/14. And then 18/5. And then there is a mismatch on page 20 between 20.5 and 2029. Those should both be August 1st. 25 is August 1st, 20.5 is August 1st, and we would suggest that 20.29 should also be August 1st. Thank you for the opportunity to testify, Madam Chair.
Thank you, Cecil. Next, we have Michael Dahl.
Good morning, Chair Mohamed, Chair Agbaje, and members of the conference committee. My name is Michael Dahl, and I'm the Public Policy Director with Homeline, a statewide tenant advocacy organization. I'm testifying in support of the amended Senate File 3492. Homeline has submitted written testimony that highlights several reasons this is the case. I'd like to just highlight a few. Homeline agrees that landlords ought not be able to deny a prospective tenant rental application because of a pending eviction or an expunged eviction. Until there's a determination in favor of a landlord, an eviction action is only an unsubstantiated claim, and an expunged eviction action shows that the courts have determined that the records are no longer relevant to the public. We also agree that every residential tenant screening agency has an affirmative duty to update and verify the current status of court files. If tenant screening agencies do not update the records, they are unreliable and possibly misleading. If the tenant screening agencies do not update the records, for example, the tenant screening agency would only show, for instance, that a landlord filed an eviction action. It may not show that the tenant won, that the parties settled, or the case was expunged by the courts. Next, tenants are often reluctant to raise anything that improves their housing conditions out of fear of retaliation. This proposed amendment ensures that tenants feel empowered to come together as a community and ask for what they need by ensuring the right to organize. Lastly, tenancies sometimes come to an end abruptly, often due to circumstances beyond a tenant's control. This bill clarifies that if a tenant has to move out in the middle of a lease term, a landlord has to make a reasonable effort to try to re-rent the property and limit the amount of financial harm. Minnesota is one of only a few states that don't already have a landlord's duty to mitigate damages in such a situation. The proposed delete all amendment of Senate File 3492 contains a lot to like. Thank you for the opportunity to highlight just a few of them.
Thank you, Michael. Thank you, Michael Dahl, for testifying.
All right. We'll now consider moving the DE in order to consider any other amendments. I'll ask that we move the DE first, then consider secondary amendments. Representative Agbaje, do you want to move it?
Yes, thank you, Madam Chair. I will move the DE amendment, which is coded A24-0330, to be considered for the conference committee.
Thank you. All in favor, say aye.
Aye.
All those opposed, say nay. The motion prevails. Are there any other amendments?
Madam Chair, I have at least probably two other amendments. Unfortunately, they'll have to be oral amendments, though. First amendment that I propose is to remove Section 8 of the DE, which starts on page 3.25, and I believe ends on line 4.21. The purpose, should I explain the purpose for the amendment? Yes. The purpose for the amendment is that this language was originally decided on by a number of stakeholders. I think after other discussion and considerations, the amendment is too premature at this point to take. And so I suggest that we remove that from the conference report at this time.
Okay, thank you. Representative Agbaje moves that we remove Section 8. All those in favor say aye.
Aye.
All those opposed say nay. The motion prevails.
Madam Chair, I also have another oral amendment to consider for the final drafting of the conference report.
Okay.
Considering testimony we've heard today, is our understanding that in the Senate, the enactment dates following the sections related to the eviction procedures for domestic violence. I think the need with the enactment dates was to show that we wanted this law to go into effect so that survivors of domestic violence could have some type of recourse should they need to leave their homes. But I think after some additional consideration, it is true that there probably does need to be at least some time to at least notify folks who are landlords and those who are in the housing business. And so I would propose that for the sections related to the eviction process and expungement process for domestic violence survivors, that we make the effective date go into enactment 30 days after passage.
Senator Verbatim.
Thank you, Madam Chair. Thank you, Representative Agbaje. I think that makes sense given the testimony we've had today. I just, serving on the Senate Judiciary Committee, just want to make sure folks know there was a lot of support for this provision. I think a lot of excitement about having this take effect immediately following enactment. I checked in with counsel about that as well. But again, given the testimony today, I want to make sure folks have time to process this change, and I think that's very reasonable.
Any other comments?
Madam Chair.
Senator Housley.
Thank you, Madam Chair. What section is that again?
That is section 8 of the bill, starting.
Sorry.
3, no, that's the section we're taking out.
Oh, sorry. This is the starting on 1.28.
Starting on 1.28.
And then,
And then we'll ask maybe nonpartisan to walk us through that.
10.24.
Madam Chair and members, there are multiple sections that deal with that subject matter. It would be sections 1 and sections 18, 19, 20, 21, and 27. Except that one of the sections, the provision that imposes the penalties, I believe it's section 20, that may not need an effective date change because in Senate Judiciary, there was no immediate effective date for the provision that provided a penalty on the landlord.
Thank you, Priya. Any other discussion on the, Mary, do you want? Okay. Cool. Seeing no other discussion, we will move that sections 1, 18, 19, 20, 21, 27 all have a Okay, thank you. Sorry about that. We will move Representative Agbaje's motion to change the enactment date for sections 1, 18, 20, 21, and 27 to 30 days after the passage. All those in favor, say aye.
Aye.
All those opposed, say nay. The motion prevails. Chair Agbaje moves that staff be instructed to,
Yes. So, Madam Chair, I'll move that with those. Oh, okay. Madam Chair, I'll move that we vote on the DE as amended.
all those, Representative Myers.
Thank you, Madam Chair. I would also like to bring an oral amendment as well.
Okay.
From the testimony that we heard and, I look at a lot of this stuff operationally and making sure that we give enough time for people to update their contracts, let people know that are either the housing providers or the people that are living there, to also look at pushing back some of the other enactment dates. I really appreciate Representative Agbaje addressing that piece, because that was one I was going to bring forward. So, I'll start with doing a motion to amend the enactment dates on those other sections to January 1st to provide some consistency.
Maybe we'll have a non-council walk through what sections?
Chair and members, this is Mary Davis from House Research. Just to clarify the amendment, do you want all of the other sections of this proposed delete everything amendment? Do you want all of the other sections to be moved to January 1, or just the sections that were highlighted by Mr. Smith?
Thank you for that. I would start with the first motion of all the sections, minus the ones that were just discussed.
Chair and members, that Senate Council and myself can determine which ones those are based on, it would be all of the sections in this amendment that don't relate to the domestic violence bill.
Madam Chair?
Chair Agbaje.
Thank you, Madam Chair. Thank you, Representative Myers, for that oral amendment. At this time, I do think that we had similar consistency last year of starting everything on January 1 of 2024. I am amenable to that amendment to make sure that outside of the sections that we already discussed that would go into effect almost immediately, that the remaining sections would go into effect January 1 of 2025.
Okay, thank you. All right, so then Representative Myers moves that all the sections that are not related to the domestic violence piece have an enactment date of January 1st of 2025. All those in favor, say aye. Aye. All those opposed, say nay. The motion prevails. Any other amendments? Okay, seeing none, I think Chair Agbaje has a motion.
All right, thank you, Madam Chair. I again move that we move the DE amendment, the A24-0330, as amended, based on the oral amendments we heard today. That is my motion.
All right, all right, Chair, any discussion? Seeing none, all those in favor say aye. Aye. All those opposed say nay. Nay. All right, the motion prevails.
Madam Chair?
Chair Agbaje.
Thank you. I think we might be getting close to the end of the agenda, so before we end, I just want to say thank you to everyone on the conference committee. Thank you to staff. I think over the past, since we passed both of these bills off the House floor, we've had a number of conversations with folks. But at the end of the day, we are glad to be able to present a bill that really encompasses the needs of tenants across Minnesota to ensure that they are living in safe, dignified places. While we weren't able to get some really important pieces in this bill, particularly the prohibition on the source of income discrimination, we are hopeful that as session continues that we'll be able to see that provision show up again in another bill on the next couple of days. But at least for now, I think it's good to say that we're supporting survivors of domestic violence to be able to move from their homes. We're supporting tenants the opportunity, the right to organize, to help make their living environments better. And we're also doing a lot, especially on the duty to mitigate, to ensure that should you need to leave your lease, you're not on the hook for the whole remainder of your lease, but that the landlord also has an opportunity, or it has a duty to ensure that they are mitigating their damages. So with those and a number of other sections in this bill, I'm really hopeful that next year tenants will start to see more of their rights realized in the state of Minnesota. So thank you, Madam Chair. And it's been a pleasure to work with you on this conference committee.
Thank you, and thank you, everybody, for your work. Thank you to the nonpartisan staff that has that. Oh, I think we'll do closing comments, so we'll start with Representative Howard.
Thank you, Madam Chair. I just want to start with thank yous to the community members and advocates that have worked hard on these proposals for multiple years, and I really do believe that we will further our goal of having more housing stability for more Minnesotans as a result of this work. And I also really want to thank Representative Agbaje, Senator Mohamed, and Senator Umu Verbatim in particular, who have been leading on these issues since the session gavelled in last year. And this really follows through on what will be a biennium of historic changes that will improve our landlord-tenant laws for our renters and keep more Minnesotans stable in their homes. This is a really, really big deal. And I'm just grateful for the leaders on this conference committee that have worked to make it happen. The last thing I want to add, Representative Agbaje mentioned that this bill doesn't include source of income discrimination. That is a high priority for a lot of the folks around this table, a lot of the folks in this room, a lot of the folks all across the state. That bill was passed as part of the House Finance and Omnibus bill, and that gives us a path here to make sure that we see this through this year. That's a commitment that I think a lot of us share in this room. And so this is a great bill, and we've even got more work to do in the next week to go. So thank you very much.
Senator Umuver-Baton.
Thank you, Madam Chair. Just want to echo a lot of those comments. I really hope that we can find a path still this session to work on prohibiting that discrimination based on how you pay for your rent. It's really important to ensure that there's stable housing. Folks who are now able to access those vouchers should be able to use that to pay for their housing. I have loved doing this work with all of you and really want to give you a lot of thanks, Senator Mohamed, Representative Agbaje, Representative Howard, to work with you all on the tenants bill that we passed last year. And I'm excited to see these provisions that we're working on this session. I think a lot of this is actually just bringing Minnesota in line with other states. I know particularly the duty to mitigate provision was really important in a place where we were behind. So it's taken a number of years to get all of these things passed, but it's really important for Minnesota to actually be a place where folks can access safe and stable housing. And just want to say how much I enjoy seeing the two of you chair our conference committee. It's just lovely. So thank you for inviting me to be a part of it. I'm really excited to support this bill.
I think that concludes our comments. I'll just add that I'll echo everything that everyone has said, and thank you to our nonpartisan staff for working around the clock to make sure that we have a DE over the weekend, and our other staff, Davin and Will and Ben and everyone else has been working really hard. I want to thank Senator Housley for the work that she's done to just sort of have been a part of this process, and really appreciate all of you, and I look forward to getting this done and continuing to protect our tenants. And with that is the end of our agenda. There are no other business, and this meeting is adjourned. Oh, the meeting is not adjourned. Redo it? Okay, we'll just clarify that. We haven't, we have one more thing. Sorry, guys. First time chairing, I apologize. So we will instruct the nonpartisan staff to prepare a conference report and give and leave them time to make technical changes and corrections to the bill. All those in favor, please say aye. Aye. All those opposed, say nay. With that, the meeting is adjourned. And the motion prevails.